In the acquisition of a business, a purchaser wants to know what they're actually acquiring, and as part of that process, the purchaser will carry out due diligence. The basic principle in buying commercial assets for a purchaser is let the buyer beware. A purchaser who cuts corners in the due diligence process does so at their own risk. Due diligence is a reasonable investigation undertaken by a purchaser to ascertain the risks and rewards associated with buying the business. It is not a guarantee or insurance there are no problems associated with the business. The purchaser will balance the magnitude of the task and the cost of the task against the cost of the acquisition of the business. The key questions that the purchaser will consider before conducting any due diligence exercise are these. 1, how does the business make its money? And 2, what does the business need in order to make its money? Checklists are often used in due diligence exercises. Generic checklists, however, do have the limitation in that they may not be applicable to the particular business being acquired. So a purchaser will always need to consider the checklist against the actual business being acquired. Sometimes vendors are reluctant to allow due diligence. For example, there may be some special intellectual property associated with the business. The purchaser may employ several strategies. This would include confidentiality agreements between vendor and purchaser, limited release of information until just before completion, or in some cases, if a particularly valuable piece of information, it might be subject to a lockup. And by that I mean that the information is only released just prior or just after completion and is a subject of extensive vendor warranties. An experienced purchaser will know what to look for in a business in which they're familiar, and so that purchaser may have a relatively limited scope of due diligence. However, an inexperienced purchaser for that particular business will typically have a much wider scope for due diligence. In each case, it's a matter of negotiation between vendor and warranty concerning the nature and the scope of the due diligence. There's often tension between the vendor, who seeks to disclose as little as possible about a business that might be sold, and a purchaser who seeks to acquire as much information as possible about the business that might be sold. An experienced purchaser, experienced in acquiring that type of business, may have a more limited scope of due diligence. An inexperienced purchaser may require a wider scope of due diligence. The material that becomes available during the due diligence process will often be required by the purchaser to be incorporated in the contract, either to be the subject of vendor warranties or may in fact form annexes to the contract. This can vary depending upon the size and scope. Particularly, it may be inapplicable in very large due diligence investigations.